3, 2, 1, start. On behalf of the respondent, it was urged that the check was given for repayment of the aforementioned loan amount of rupees 30 crore, for which the accused company agreed to repay the principal amount in two installments, with first installment of rupees 10 crore payable on 31/03/2015 and the second installment of rupees 20 crore. Stop. The accused company had to pay interest at the rate of 15% per annum on the said principal amount of loan, and such interest was payable monthly on the 15th day of every month, which was in consonance with the dates and the check amount. Stop. It was urged that the accused company, along with the appellant, deliberately and with the malafide intention, gave the check to defraud the respondent to take loan from it and subsequently to usurp the loan amount, and hence had closed the bank account. Stop. The appellant, being the signatory, was directly liable along with the accused company. Stop. The appellant was actively involved in the day-to-day affairs of the company, as can be inferred from the aforementioned loan agreement signed by him as well. Stop para. We may note that some of the SLPs being withdrawn, in respect of the SLPs in question, the interim order was made absolute with the direction for urgent listing, as criminal proceedings had been stayed. Stop. Learned counsel for the parties stated that they will file short synopses not running into more than 3 pages each and will not take more than 15 to 20 minutes each for their respective submissions. Stop. On the basis of the aforesaid, we heard the arguments when we granted leave and reserved the judgment. Stop. The appellant had submitted the synopsis in advance. Stop. The respondent, however, despite assuring that they would submit the synopsis, has not cared to do so, and we have gone on the basis of the record. Stop. This position is prevalent, right, and we do not consider it appropriate to wait anymore. Stop. We assume that the respondent is not interested in rendering any further assistance to the court by filing synopsis. Stop. Fortunately for them, for the reasons to be recorded hereinafter, they have not really suffered the consequences thereof. Stop. The issue whether the respondent is a secured financial creditor or an unsecured financial creditor within the meaning of the said code is not something we can deal with the proceedings under the said code or any appeal preferred therefrom. Stop para. The only issue with which we are concerned with is whether during the pendency of the proceedings under the said code which have been admitted, the present proceedings under the NI Act can continue simultaneously or not. Stop. We have no hesitation in coming to the conclusion that the scope of nature of proceedings under the two acts are quite different and would not intercede each other. Stop. In fact, a bare reading of section 14 of the IBC would make it clear that the nature of proceedings which have to be kept in abeyance do not include criminal proceedings, which is the nature of proceedings under section 138 of the NI Act. Stop. We are unable to appreciate the plea of the learned counsel for the appellant that because section 138 of the NI Act proceedings arise from a default in financial debt, the proceedings under section 138 should be taken as akin to civil proceedings rather than criminal proceedings. Stop. We cannot lose sight of the fact that section 138 of the NI Act are not recovery proceedings. Stop. They are penal in character. Stop. A person may face imprisonment or fine or both under section 138 of the NI Act. Stop. It is not a recovery of the amount with interest as a debt recovery proceedings would be. Stop. They are not akin to suit proceedings. Stop para. It cannot be said that the process under the IBC, whether under section 31 or sections 38 to 41, which can extinguish the debt, would ipso facto apply to the extinguishment of the criminal proceedings. Stop. No doubt, in terms of the scheme under the IBC, there are sacrifices to be made by parties to settle the debts, the company being liquidated or revitalized. Stop. The appellant before us has been roped in as a signatory of the check as well as the promoter and managing director of the accused company which availed of the loan. Stop. The loan agreement was also signed by him on behalf of the company. Stop. What the appellant seeks in escape out of criminal liability, having defaulted in payment of the amount at a very early stage of the loan. Stop. In fact, the loan account itself was closed. Stop. So much more the bona fides of the appellant. Stop. We are unable to accept the plea that if proceedings against the company come to an end, then the appellant as the managing director cannot be proceeded against. Stop. We are unable to accept the plea that section 138 of the NI Act proceedings are primarily compensatory in nature and that the punitive element is incorporated only at enforcing the compensatory proceedings. Stop.